Good afternoon, Anteaters, and welcome to this, what will be a really fun Lunch and Learn event, our Lunch with Eaters series. This is actually the 20th installment of our Lunch with Eaters series, which is a monthly virtual Lunch and Learn program built specifically for you, the UCI alumni and friends community. I'm Jeff Minhas, Executive Director of the Alumni Relations, and I'm excited to be joined by a very exciting guest speaker today, who I'll introduce momentarily. But first, just some event logistics. First of all, we have a website full of resources, archives of videos of so many of our past events. We've been doing about 4, on average, virtual programs a week in the past year or so over the course of the pandemic. So we have this huge library on our YouTube page of previous events with a variety of different topics. So I invite you to check that out. On our website, there's an upcoming events calendar, ways to get involved with supporting students and young alumni via mentorship, ways to join alumni chapters, and other ways to get involved with the university. So please check that out. Now for this event, you're all muted audibly. However, we want to encourage as much participation as possible. So use the chat. We also have Q&A enabled. We will dedicate about the last 15 minutes of this event to Q&A. So throughout the event, if you have questions for Puya, we encourage you to put those in the Q&A, and then we'll circle back to as many of those as we can as the event winds down. Okay. So with that said, without further ado, I'd like to introduce our featured speaker for today. Puya Agahi, class of 2011. Upon graduation from UCI, Puya started his career at the U.S. Patent and Trademark Office, where he has been reviewing medical patent applications in his role as primary examiner, and has granted several hundred patents over the years to companies such as Fitbit, Edwards Life Sciences, Medtronic, Johnson & Johnson, Omron Healthcare, and Apple. He earned a BA in biomedical engineering from UCI in 2011. When he is not reviewing patent applications, he enjoys spending time with his wife, who he met during his anteater days, going on hikes with their black lab, and playing basketball. Everybody, please join me in giving Puya a great big virtual anteater welcome. Welcome, Puya.
Hey everyone, first off, thanks so much, Jeff, Jessica, for putting this all together and having me for the, I believe I heard the 20th installment of this Lunch with Eaters series. So I'm really thrilled to be here, to be able to share a little bit about my experience working at the patent office and answer any questions you may have. So thanks again for having me.
Yeah, it's our pleasure. And I know you may have even been a little surprised how much interest there was in patents in your field, but there is a lot of interest. We got a great response from the alumni community, so we're excited to learn from you today. But first, let's get to know more about all of our shared connection is the anteater experience. So maybe you could start with your favorite 1 or 2 memories from your days at UCI.
Yeah, sure. So, still echo. So as you mentioned, you know, I met my wife there during my days at UCI. So that's probably going to be top tier memory number 1. We were both in the dorms together in Mesa Court. I was in Palo, she was in Cielo. So those were always fun times, getting to know each other over the course of our relationship. And aside from that, I'm kind of a basketball junkie. I love going to the Arc and playing pickup games, usually in the early AM days. They'd have these firefighters who'd come there. I'd play with them a bunch. And I remember on 2 separate occasions as I was leaving, I got to see Kobe Bryant, and that was pretty cool. I'd always hear people running into him, and just to see him twice in a week I'll never forget that. And aside from that, you know, tons of memories just studying and making flashcards until 2 a.m. at like 5th floor science library. So a lot of fun memories there at UC Irvine.
I'm sure many alumni in the crowd can relate to that, spending days at the Arc since it opened in 2000, and the science library, Mesa Court. Yeah, so we've all gone through those halls. Now, after you graduated, what drew you to the patent office?
Yeah, so as an engineering student, I was always thinking about employment my junior year, and I had this family friend who had been working at the patent office since like the 80s, and he'd always raved about it and how great of an experience it was. And he recommended that I apply just to be an extern over the summer going into my senior year at UC Irvine. So I thought I'd give it a shot. I applied and I spent, I think it was like a 6 week externship program in Virginia. Luckily, I had family there, so I just crashed on their couch. And I really liked the area. I really liked the DMV area, and the campus was just something else. Like the patent office has this huge flagship office there, and just getting a taste of the overall patent process, I knew like I could make a career out of this. So I kept my eye on job listings thereafter, and there was a position for a biomedical engineering patent examiner that I applied for. And I was able to start working there shortly after graduating UC Irvine. So yeah, once I started there, I never looked back. You know, I still work there, and no regrets whatsoever.
That's awesome. Sounds like a great fit. Now, you you obviously have the qualifications, but what are some of the qualifications if anyone is interested in going into your field for your type of role? What are the qualifications?
So the patent office is kind of like a niche organization where in order to apply, you need to have some kind of engineering or technical background. That's the main hurdle. So if you got like mechanical, electrical, aerospace, biomedical, computer science is also pretty big. One of these engineering disciplines is what you need to apply to be a patent examiner at the U.S. Patent and Trademark Office.
Thanks for sharing that. Now, did you get paired with a specific unit in the patent office?
Yeah, so when you think of all the forms of patent applications that come into the office, you know, they need to be routed to a particular individual who has that requisite skill to be able to examine the type of technology that you're seeking to protect. So based on my experience at UC Irvine as a biomedical engineer, and I think in my senior year, me and a few colleagues worked on this really cool project where we developed this cost-effective bubble CPAP ventilator for infants with sudden infant death syndrome. They took all that into consideration in my patent application, in my application to be a patent examiner, and they paired me into an art unit that focuses with that technology. So I'm considered, I guess, one of ordinary skill in like medical diagnostics, like wearable patient monitors, ventilators, and like implantable medical devices and that sort of thing. So those are the applications that I see and review for patentability.
Very cool. Now, there's something else about your career path so far that we didn't mention in your intro, and that's that in 2018, you decided to take the LSAT and apply for law school. Can you tell the audience why you decided on this route and maybe what you hope to do with that degree?
Yeah, absolutely. So the patent office is kind of a unique federal agency in the sense that, you know, unlike a lot of other federal agencies that accrue their funds from taxpayer dollars, the patent office is actually self-funded. They get all their money from patent fees. And because of that, they have this huge repository, this huge budget, and they can provide their employees with like higher learning initiatives, one of which is they'll subsidize your legal education. So I wanted to take advantage of that. 2018, took the LSAT, got accepted into University of Denver, where I live in Denver now, go to law school here. And I hope to, you know, use the JD to further my career with the office, or, you know, I could potentially one day get into patent litigation, or, you know, long-term goal, maybe become a patent judge for the Patent Trial and Appeal Board. So those are some far off goals that I have, but right now I'm just working on getting that JD. I got one more year left to go.
Well, that is definitely the smart thing to do, taking advantage of subsidies for further education from your employer. Kudos to you. Now we're going to transition a little bit, but first, for the audience, pull up your Zoom. We've got a pop-up poll question. We just want to know a little bit about you. What drew you to this webinar topic? either you want to get into the field of patents, you're generally interested, you're an inventor perhaps, directly relevant, or another reason. I hear about patent issues a lot in the news, of course. Everything from patent trolls to patent grants, local biomedical companies, there's a lot of them in Irvine. Most of the audience, 60%, are generally interested in the topic. And we've got a handful of inventors and folks who want to get in the field too, Puya. So interesting. All right. So now we'll kind of move into the patent world itself and transition. So question for you, just kind of opening the topic. For those of us normal people, how does the Patent Office operate and what's its history?
All right, so like many federal agencies, the Patent Office actually stems from our very own US Constitution. I think Article 1, Section 8, Clause 8 is often referred to as the Intellectual Property Clause. And in it, Congress is to promote the progress of science and the useful arts, giving these individuals who, either invent something or create some artistic thing exclusivity to those. And fun fact, Thomas Jefferson is often regarded as the first ever patent examiner. When George Washington was president, Jefferson was in his cabinet as Secretary of State. He also had another role to review patent applications. And he quickly realized this is a lot of work. I can't do this and be Secretary of State. So Congress passed the 1790 Patent Act, which created the first patent office. And if we fast forward today, the agency has just grown exponentially. And we have our flagship office in Alexandria, Virginia, along with a few satellite offices sprinkled across the US. We got one in Dallas, Silicon Valley, Detroit, and where I live in Denver. And the agency as a whole comprises about 10,000 employees. Most of them are patent examiners like myself. We have like 500 or so trademark employees and then administrative staff. So it's a fairly large agency that's tasked with just reviewing patent applications from various technological areas.
That's great. Now, we already have a question in the chat, so I'll bring it up. Are there opportunities to telecommute in your role or remote work?
Absolutely. So even pre-COVID, the Patent Office is actually renowned for for having such a robust teleworking infrastructure. I think in 2014, they were rated #1 best federal agency to work because of this program. Basically, this is pre-COVID. A lot has changed since, but pre-COVID, as long as you work for the Patent Office for a handful of years and can meet production, and I think you had to have passed some certification exam, you can basically work anywhere in the continental US remotely. You can also have the option to work remotely part-time and go into the office, like one of these satellite offices I mentioned, or Alexandria, Virginia, the flagship office. So they offer a lot of flexibility. If you want to be like fully remote, you can do that. If you want to like be in the office for like 3 days a week, at home 2 days a week, you can do that too. And they recently expanded to being able to do this in Hawaii and Puerto Rico as well. So it's really, really crazy what they've been doing. But like COVID, everything changed everything. Now you don't even need to meet those bare minimum requirements. You can work fully remote from day one. They will send you all the equipment, your monitor, your computer, your keyboard, all your router, all this stuff that you need. I have a colleague right now who's being trained at the Patent Office, and typically you go into the office and there's a 3-month academy period. He does that at home. So it's just really insane what you can do if you want to pursue a career in patent prosecution. There's a lot of flexibility afforded to you.
Wow, very, very much ahead of the curve. And I can see why it's rated the best federal agency to work for with the further education subsidies and the flexible work environment. That's fascinating. All right, so back to patents themselves. What does the patent process look like?
Right, so basically if you're an inventor or you're someone who's working for a company, you want to submit a patent application, you need to describe your invention in words. You need to provide a claim or claims rather. You also need to provide the technical documentation to show that you actually came up with this invention, drawings and all this sort. You package that all up and you submit it, you file it to the patent office. And an examiner who has the skill that pertains to the technology that the patent is seeking to protect will review it. Now, if you've ever watched Shark Tank and you see Lori Grenier's eyes light up when she's like, when she finds out this entrepreneur has patents or is patent pending refers to just like someone like me is in the process of reviewing your application. That's all that means. And so how it works on a high level is in, I think, 2012, the patent office became what's called a first to file system. So it incentivizes inventors to file their patent applications immediately. And once you file it, you're given that date. That's that date is very important because if you're ever to have your patent granted, you're offered exclusivity rights to this idea for 20 years as of the date that you filed for that patent application. And so also how it works is when someone like me is reviewing your patent application, I'll have to conduct what's called a prior art search. I have to make sure what you're giving me is actually never been done before and is also not obvious, right? So I do my research. I use my database to look at prior patents that came before you to see if what you're claiming is actually novel. And I'll also look at other things, PhD dissertations, published articles, YouTube clips, anything that was published can be used as what's called prior art to show that you were not the first to come up with this invention. But once you pass that back and forth with the examiner, which could take anywhere between a few months to a few years, depending upon, I guess, the attorney that you hire or whatnot, you're granted a patent and you're granted this right of exclusivity to your idea. You can license it out to people. You can prevent others from encroaching on it for 20 years. So that's generally how it works.
Wow. Okay. So there are individuals who file, and then there are companies who file, and that's always kind of confused me. I actually have a cousin who, for his company, I think, has more than 1,000 patents, but they're in his name, I guess. How does it work differently for an individual and a company?
Generally speaking, the process is more or less identical. The only difference is if you're an individual, i.e. not someone who's working for a company, if you're an individual, you hire a patent attorney who you meet with, they write up the patent application for you. And if it gets granted, you have full ownership of the patent. Whereas if you're working under the umbrella of a company, they're going to obviously take care of all your fees, your patent fees, your attorney fees. But when it's ultimately said and done, when it's granted, the company owns the patent. So your name will be on that patent if you're under the umbrella of the company, almost like in a ceremonial way, like you don't own really ownership of that patent. So that's basically the key difference.
Got it. Okay. So, they're the patent, but then there's also intellectual property. And, this is kind of nebulous to someone like me and those in our audience who don't necessarily understand all of this. What are types of intellectual property?
Right. So I mentioned I work at the US Patent and Trademark Office. So right there, my office deals with patents and trademarks. Patents are like the bulk of what we do. I would say like 95% of the workforce at the USPTO deals with patents, but we do have like 500 of the 10,000 employees at the USPTO that deal with trademarks. So with a patent, you're essentially getting exclusive rights to some idea, invention, some utilities involved, right? Whereas with a patent, it's a limited life term. I mentioned you have 20 years of essentially a 20-year monopoly for this idea. Whereas with a trademark, if you think of like McDonald's, Coca-Cola, any of these big corporations, they are able to use the same logo in perpetuity. And the thought of that is trademark rights are the purpose is to prevent customer confusion. So I always think of that movie Coming to America. I don't know if anyone's, you've probably seen it, where the McDonald's arches, McDarrell's, McDonald's or whatever. Yeah, that's that McDonald's would have a really good trademark lawsuit against them because they're confusing customers or whatnot. The other type of intellectual property out there, we do have a separate office. It's the US Copyright Office, and that is protecting, artists, media, film, and all this stuff. I don't deal with that. It's a separate office altogether. And lastly, there is trade secrets. So, difference between that is you can have protections for some secret formula, for instance, without actually having to disclose that formula to the office. So if you think of like Dr. Pepper, Coca-Cola, they have some secret formula that they're protected by. No one can infringe on that. But so I mainly deal with patents, and that's the level of expertise that I have knowledge in. I always think of like, let's say Bluetooth, for instance, like that technology is pervasive. Any mobile device that has Bluetooth now is because the patents for that have expired. So, the main distinction there is that the 20-year period of exclusivity that you get granted from the USPTO once you have that valid patent. So it's not in perpetuity. That's the main difference really with like a patent as opposed to a trademark. I also always compare like patents with like real estate, in the sense that they're all similarly like you get a piece of property to enjoy the rights of exclusion from others. You can grant people licenses to come over to your house. Same with patents. You can grant people licenses to use your technology, but after 20 years, unlike real estate, it's everyone's.
Wow. Okay. So I've got some follow-up questions to that. First of all, why 20 years? And second of all, you mentioned Bluetooth as a good example. Does that mean a technology or a technological standard has to be 20 years old before it can be widestream adopted? And does that mean it's dragging our technological advancements moving forward?
I guess the thought process is you want to provide inventors with the credit that they deserve for coming up with something very groundbreaking, but you don't want to shatter ingenuity altogether by giving someone like unlimited monopoly, for centuries to come. Otherwise, in our capitalistic society, you're only going to have one company that takes over everyone else. You want people to emerge as well and come up with their own ideas to contribute to society and whatnot. And another thing that the patent office does to address that, they have different filing fees for depending on if you're a large entity or a small entity. So essentially, if you're a smaller company, you get a reduced patent filing fees, because they want to encourage ingenuity to continue on with everyone, not just like people who can afford it. I don't know if that answered your question.
Yeah. No, that makes sense. So some more questions for you, and I can't wait to get into the Q&A because we've got to follow up on what you just said. But back to intellectual property, what do you like most about reviewing IP submissions?
What I love the most about the office is the flexibility that it affords. I alluded to the work-life balance. I spent 7 years living in Virginia, and then I moved to DC, and then I moved to Orange County to live, for a few years, relive my Newport Beach days when I went to UCI, and then now I'm in Denver studying at the law school. So it's just, I wouldn't be able to do that without this job, without the expansive teleworking opportunities that they afford their employees. And then the fact that they're willing to, pick up the law school dime. That's just, I don't know many agencies that do that. But aside from that, just from a personal standpoint, I do really enjoy seeing what the cutting edge of technology is in healthcare, right? Like I'm in a really interesting field where I get to review all these biomedical applications, and I get to see what these big companies want to fight over. And to me, it seems like we're heading in the direction of like at-home patient monitoring seems to be where we're headed towards. Like I'm sure you or me right now wearing one, you probably know someone who has an Apple Watch, there you go, a Fitbit or some kind of device that is tracking your physiological data over a large period of time. And that it makes sense. Like you want to have a more accurate diagnostic indication of your health, right? As opposed to going to the doctor, seeing them for like waiting for an hour and then seeing them for like a 15-minute short window. They'll take your heart rate, they'll take your blood pressure and all this stuff. And they're supposed to make a diagnosis of you on such a short frame of time. Like, okay. I mean, yeah, there's a lot of benefit to that. Don't get me wrong, seeing someone face to face. But I think with more data comes more accuracy. That's the field we're in. And then with AI, machine learning, all that stuff, these fields are all intersecting, and it's really cool seeing how technology is kind of emerging, how we're merging into what is going to become healthcare in the coming years or whatnot. Yeah, I always think of like kids with diabetes, for instance. They like 10 years ago, they lived a very abnormal life, to say the least, like always having to, monitor their blood glucose levels and, making sure they're eating enough or whatnot. Now with technology, have these like wearable monitors that, you can track on a continuous output. And there's also a feedback loop system too, that they can provide these kids with insulin. You can send your kids worry-free to sleepovers, track their levels while they play soccer games and whatnot. Like,
Yeah.
it's really amazing where we're headed towards. So I'm really excited about that, and seeing that reflected in patents is pretty cool from my standpoint.
Yeah, you get to see it coming around the corner. And I can speak to that briefly. I was alerted to a heart issue with my son because his Apple Watch realized he was over 200 BPM for a couple times, and that wearable, that's technology these days. This is in-home kind of diagnostic stuff. So absolutely fascinating. Now, speaking of that and kind of what you see now, what does the patent agency look like in the future? What are trends in your field here?
I would say COVID really changed everything for so many industries. I'm very curious to see like what the patent office will do with these satellite offices in our main flagship office, because everyone's working from home right now. Not just the patent office, as even though we see a light at the end of the tunnel with this pandemic, I imagine that the work from home capabilities are only going to stay with the patent office, and maybe they'll still afford you with the option to go in, like they've done in the past. But they haven't really given us any update. And being a federal agency, they're usually very conservative with their approach during these times. So I can't imagine things are going to change for us in terms of being able to stay in our current work from home roles. And which is also really exciting for people who are interested and want to get into this field, because you can essentially start being trained as an examiner from the comfort of your own home, which is pretty cool. They'll send you everything you need. Whereas how I did it, I went into the office, I went into the academy for 3 months, and then I had to pass a few hurdles before I can work from home full time. They probably will waive that right away. So that's pretty exciting, I think, for someone who's interested in getting in this field of patent prosecution.
Yeah, I think you've sold it pretty well. There's probably people in the audience who are interested. So if they are, can you share if there's any internship or postgrad opportunities for students maybe, or even young alumni on the call here, just, to try to get into your field?
Yeah, absolutely. So what I would recommend anyone who is interested in a career with the USPTO, or just maybe even wanting to dip your feet in a little and do the externship like I did, I would go to usajobs.gov. There's a search box. You just type in patent examiner, and there's always listings there. There's always job opportunities there. Like, I think I checked it earlier this morning. There's 10 openings for various patent examiner positions. I didn't see the externship. I don't know if that has anything to do with the current state of the pandemic. But if you're going to graduate soon, or if you are, a postgrad or whatnot, and you want to try something different, I'd give it a shot. I would apply. Just need to have an engineering background, and then if you have any questions, you can feel free to reach out to me. The USPTO.gov is a pretty good resource as well. But I'd highly recommend it for anyone who wants to get a sense for how the patent process works.
Great. All right. So this has been very informative so far. I think we'll get some more depth here, because now we're going to transition into audience questions and answers. So we've already got some great ones. if you have any questions, things on your mind to ask Puya, put them in the Q&A. I see some in the chat. We'll get to those, but please put them in the Q&A so we can get to as many of them as possible. I do want to point out there was one really adept comment from our great colleague, Goran Matijasevich at UCI. This is obviously an area that UCI and all universities are very interested in. UCI is a globally preeminent research institution. Part of that research is inventions, patents, IP. We have a wonderful resource, which is new in the past 5-6 years, called Beal Applied Innovation. We also have facilities for that, the Cove at UCI. And we try to get IP out onto the market, and the university will share the patent income if you work at the university as a researcher or faculty. UCI will share the patent income with you. Usually, perhaps 35% goes to inventors after covering the cost of attorney and patent fees. So you could do this as a university employee as well, if you're interested on that side of it. Now, first question goes to Steve Ackerman. Hey, Steve, thanks for joining. Steve asks, does your position as a patent examiner necessitate that you divest any personal investments in companies that develop products in your patent space?
So I should say right off the bat, one thing about being a patent examiner means that I cannot invest any of my money into companies that I examine. And I'm also barred from ever applying for a patent application while I am employed by the US Patent and Trademark Office.
Okay. Yeah, I think that probably makes perfect sense. Now, a lot of folks asking about going through the process as an inventor, perhaps. So Tisa Shavers, hey Tisa, she asks whether you need an attorney to go through this process, and what is the benefit of an attorney when filing for a patent?
I would say you don't technically need an attorney, but it is highly recommended. Sure, you can be what's called a pro se applicant, but chances are, if you're not well versed in patent lingo and with changing law, you could run into some obstacles that, had you hired a patent attorney, would not have happened. So I'd highly recommend, meeting with a patent attorney, getting some information, because a lot of times from the examiner's point of view, I've never had a pro se applicant, but I've had colleagues who've had pro se applicants, and it's hard for them to even get through the initial hurdles because there are a lot of deficiencies with their patent applicant that, had they had a patent attorney, they would have had those resolved from the start. It's always something that I always encourage inventors, just having casual conversations, get that consultation, talk to a patent attorney, because they know what they're doing, and chances are they'll do you more help than harm. So that's what I would recommend.
Great. Now, once you get it started, how long does the process take for a filer?
Sure. So it varies is the answer, but it averages usually, we try to be under 18 months from the date you filed. But there are incentives in play where you can file what's called expedited reviewal of patent applications. So of course you pay a little more, but chances of you getting a patent validated quicker is increased. I've granted patents. I've seen patents being granted after a few months. I've seen them take, a few years as well. It's really just depends on that back and forth with your attorney and that examiner. And how you claim your invention. If you claim it's super broad, that it, encroaches on so many different prior references, you're gonna have to overcome those hurdles. But if you are more narrow in your approach, you might be able to get a quicker patent. So really, it's really variable, I should say.
Great. So Lawrence Hayes asked that question, by the way. Thank you, Lawrence Haynes. Since you brought up fees, here's a question from David Witt. If you had an idea for a new product and thought a patent would be useful for protecting it, and you were just starting out on your own, would you A, apply for a provisional patent for about $500. B, complete a prior art search and patentability opinion for $3,500. Or C, jump in and start the full patent for about $13,000. What's your recommendation?
Wow, that's a really great question. So let me see. So we have the 500. What was the middle number? 3,500, I think it was.
That was 3,500 to complete a
Okay.
prior art and patentability search.
Okay. So I should say, if you ever want to get a patent, eventually you will have to pay that full-blown third highest value that you mentioned. But there are benefits to those other avenues that this individual was asking about. A provisional, for instance, yes, it's much cheaper. So it gives you like that filing date. That's the magical date you need. So you could go the $500 route, file the provisional, lock in that date, and then on your own accord, you can do some research to see what's out there, right? You can, I don't know, search patent databases, which are all available to the public for FYI. So you can invest that very minimal capital, lock in that date, and see if it's worthy to just go full in on that full-blown patent application when it's time to do that. I think you have a year to do so once you file that provisional. So it really depends on the resources you have, how confident you are in the product, your level of knowledge in the area. So those are things to weigh out.
Yeah, David, I think that's a very relevant question to a lot of people. They may not be inventors, but they have a good idea and are wondering how to get it to market. All right, so related to both of the last questions, here's one from Christopher Schmitz. Is it reasonable to file a patent without a lawyer to save money? Or does that put you at too much risk for having your patent invalidated later? He's heard about patents being invalidated because there wasn't enough investigation into prior art before filing. Would you be more at risk if you haven't hired a lawyer to ensure that investigation is done?
Yeah, it's hard to answer that question without a little more specificity, but the short answer I would say is an attorney will do more good than harm for you. They will be more thorough in a prior art search, and they will know the right legalese. They will know the right ways to claim your invention in a way that captures the most scope, so to speak. So, I mean, but in today's world, with how expensive things are and how you can learn whatever you need to learn online, like I'm sure if you're savvy enough, get behind that keyboard and learn everything about filing and the process, non-final rejections, final rejections, all these back and forth with the office, you could probably do it without an attorney. I just would never recommend to do it unless you've really taught yourself the ins and outs. And it's a pretty complicated field. So that's why I always stray away from people who wanted to do this on their own. Sure, you can do it, but man, it'd be much easier if you just had a professional do it for you.
Got it. All right, so moving into a new territory, BJ Hooper, who coincidentally failed at pursuing biomedical engineering in undergrad, he asks, what's the difference between an inventor or someone who gets the credit and monetary gain from a patent and an individual or small entity who just have an idea or concept that lacks the financial backing or funding? So I think he's asking, what's the difference between an inventor and someone who has an idea that doesn't take off?
I guess technically they're both inventors if they both came up with something. Yeah, the latter guy just sounds like he needs a few shekels to file a patent. I don't know if I understand completely that question, but typically speaking, when you're an inventor and you want to file for a patent, hire the attorney and you get the sole rights of that granted patent. But if you are an inventor who works for like Microsoft or someone, that Microsoft is considered the assignee and they will own the rights of that patent should it be granted. That's the difference between that. I don't know if that's the question that was being posed, but apologies if that didn't answer it.
Yeah, I think you covered it. Now, more specifically on patents themselves, can you elaborate more? Because we've heard these terms tossed around. What's a design patent versus a utility patent?
Sure. So a utility patent is basically something that gives you exclusive rights to an idea, a device, some tangible thing or some method of some sort. Whereas a design patent is just like giving you protection for the ornamental features, how something looks, so to speak. Utility patents are definitely stronger if you can get them granted. I don't deal with design patents too much. I deal with mostly utility patents, but that's the main thing. It's the utility versus the design or ornamental features of your patent, how something looks.
Great. So I'll just remind the audience, if you do have any questions, feel free to drop them in. We've got another one here. You can choose to answer this one or not, Puya, but this is another one from Lawrence Haynes. Have you ever been wrong in allowing or disallowing a patent? If so, what happened? And I suppose you could speak to yourself or someone else maybe you saw in your field. What happens when something goes wrong?
So I'll answer that question very frankly. There's a lot of subjectivity when it comes to patent review, right? Like if you invent something and it's never been done before, it passes what's called the novelty test, right? So that's good. But just because you have a novel idea doesn't mean it's non-obvious. It needs to also pass the obviousness test. That latter portion is where there is a level of subjectivity. What I think might be obvious, someone else might disagree with. So sure, I'm sure actually I've granted a patent that I thought was non-obvious. But there are mechanisms in play where you can challenge the validity of a patent once it's issued. I think it's within like 9 or so months, and the challenger must provide evidence showing why they think it would be obvious, right? So I'm sure there have been cases where their institution was granted, for instance, and the board agreed with them that yeah, there might be a means for invalidating this patent under grounds of obviousness. So, but they don't really notify you when that happens. So I can only guess that has happened. If that makes any sense.
So they don't notify the examiner when that happens?
Not really. It's really when that happens, it's really the office in general is responding to that. It's not like they ever label out a particular examiner. We're shielded by that. So yeah.
Okay. Now you just mentioned a board. What is that board?
So we have in 2012, Congress passed a law. It was called AIA, America Invents Act. And with that law came with the creation of what's called the Patent Trial and Appeal Board, PTAB for short. That's our board. And basically gives people another avenue to try to invalidate patents. Traditionally, it was really costly going to federal district court, like millions and millions upon dollars for doing these lawsuits. Whereas if you go to the PTAB within 9 months, or I think it's 9 months of when a patent is granted, a third party can, like I alluded to before, provide a request for institution to show that this patent should be invalidated for some grounds. So that board functions in that capacity. They also function in other capacities as well, where the patent applicant, maybe they don't agree with the examiner, they can appeal the patent examiner's rejection and go to that PTAB, and then there will be a conference to see whether or not the patent examiner's rejection shouldn't be maintained or not. So that's what we mean when we refer to the board. It's this administrative body of judges that the Patent Office created in 2012.
That's great. I'm sure that's a better route than putting everything through court. Thanks for sharing. A couple more interesting questions. Robert Sau. Hey, Robert. He asks, how do international patents work? More specifically, is a US patent enforceable in Asia? And how would you need to structure it for maximum cross-border coverage?
Good question. So every major nation has their own patent office. You get a valid patent and you get protection in the bounds of your own country. But there are, I think, international organizations where you can apply for an international patent and it'll be valid for like a conglomerate of nations. In terms of like, if you file for a US patent or a foreign patent and how they can be used against each other, I think with the current rules, they can, as long as, like, say if you filed in the US and you filed in, say, maybe Italy within a year later, you're okay. But if you file in Italy after a year, that US patent can be used against you as prior art, is my understanding. I'd have to double check that.
I'm sure there's a lot of that, especially in tech, hardware, perhaps. Okay, another fun one, Lawrence Haynes. What is the most unusual patent request you've received?
Unusual patent request. I'm not sure how to answer that question. I get like interview requests all the time, but those are, we generally allow for inventors and their attorneys to have one interview per round of prosecution. Sometimes you'll have an attorney who really, wants to talk after every single correspondence, which can be kind of tedious and, quite frankly, annoying. So that's one thing that would be kind of weird or whatnot. But generally speaking, when you apply for a patent, the patent office is supposed to, we're supposed to be collaborative. It's not really an adversarial process. We're really here to help inventors reach their end goal. And one of those ways we do that is by offering a 30-minute interview to discuss, any issues, to hear what their invention is and whatnot. So, when sometimes attorneys try to game the system and milk us for more than we typically are comfortable in providing, that gets kind of annoying and tedious, but that's pretty much it.
So you do have direct interaction with the patent filers?
Yeah, so through their attorney, but sometimes their inventors will also want to be on the call. And I like that personally when the inventor is on, because I get to hear their life's work. I get to hear like what the invention is from their eyes. And that helps aid me in my prior art search to see like where I can focus my search on, for instance. They're more candid, I find, whereas attorneys are, sometimes they can be a little more cagey and not tell you the complete story. But inventors, you can tell they're very passionate about what they're doing. And, so yeah, I do have the direct interaction.
Oh, cool. Okay. Another question for those interested in your field. Do you know the general starting salary or pay scale for entry level in your field?
Yeah, so the patent office, like other federal agencies, generates on the general services pay scale, the GS grade. So if you Google, like, I don't know, patent examiner salary GS grade or something like that, there'll be a chart and it tells you, GS7 corresponds to this salary and whatnot. I was hired as a GS7 step 9, and I think their starting salary back then, which I'm sure has gone up now, was like, I don't know, like 67 grand, which to me sounded like a lot of money coming out of undergrad. So I was like, oh yeah, let's do this. Sounds good. But I'm sure with cost of living increases and all that stuff, it's gone up. So yeah, that's something that's publicly available.
Oh, cool. Cool. Do you work or do you receive patent applications from universities? Can you even tell that like they're from researchers at a university?
Oh yeah, absolutely.
Okay. So a couple specific questions about that, or at least one. What if a professor, and I don't know if you see this side of it, but what if a professor works on a project with students, like they're graduate students, and then those students graduate, move on, but then the professor kind of goes forward with a patent application? Do you know if like who gets credit, who gets revenue for those kind of things?
Short answer, I doubt the student gets any recognition. I would assume the recognition would go, the inventor would be labeled as the professor. And then the patent, I'm assuming, would be under the umbrella of UC Irvine, for example, so they would have ownership of it. So, yeah.
Okay, great. Now, you mentioned these 4 different areas: patents, trademarks, which are both in your office, although separate areas. Then there's the copyright office, and then trade secrets, which I think sounded like a separate office as well. Anthony McCollum asks about code and whether code is available for patent or copyright, specifically, in tech. Wearable devices are driven by code. Hardware is as well. Is code available for protection on any of those fronts?
So with code, it gets a little tricky. There was a Supreme Court case in 2014 that kind of shocked the patent world, in the sense that if you're claiming something that could be arguably math or an abstract idea, or something that's just like a generic computer function, like if you're trying to get a patent on something that captures the generic capabilities of a computing device, you'll have some patent eligibility issues. Now, whether you can get protection under maybe copyright law is a different story. I don't know, maybe not. I'm not sure. I don't really deal with copyrights, but with patents, it's a little gray right now when it comes to code and software. So that's something to keep note of. And we haven't really gotten much updates since that 2014 Supreme Court case. So it's really unclear at this point. I would say if you are going after code, claim your invention in a way that's heavily rooted in structure. So it's more focused on like the actual device and less on the computing functions of that device, if that makes sense.
Yeah, fascinating. And yeah, a changing field. You're getting your JD, but staying up with case law, I'm sure is as relevant as anything. I know you don't deal with copyrights, but Lawrence again asks, can you explain the difference between copyright and patent? And he asks, for example, can he patent his dissertation or articles?
Right. So you can get like when I think of a copyright, I think of, when you flip the first page of a book, you'll see all that copyright information there. When, you can't like copy a film because of copyright law and whatnot. So you're really getting protection for some piece of literature, piece of art or whatnot, something that's not like an idea. I guess it is an idea, but something that's it's different from a patent in the sense that you're not getting protection for like a concrete device or a method or something like that. You're getting device on, your creative work. So that's the main difference in terms of the logistics and how people go about getting that copyright protection. I don't think it's as expansive or as complicated as like getting protection for a patent. I think with copyrights, it's almost like you have to register your copyright and you're good to go. So there shouldn't be too long of a wait period in my level of understanding. I could be wrong. I'd look more into that though.
Awesome. Well, this has been revelatory, but we're going to end it on one final question, and it's a fun one. Back to your ARC days, you saw Kobe. Did you ever challenge Kobe to a one-on-one game at the ARC?
Oh, I was so shocked. I was just mystified by this, legend walking by me. I just stopped and looked. I didn't even say one word to him. It was just, I think I was like either entering or leaving the ARC, had to tie my shoe, and he just walked by me. That was the first time. The second time I saw him just in the weight room, and everyone was just kind of peering in the window. So I let him be. I didn't want to mess with him there. I don't think he really came to the ARC to like work on his game. I think it was mostly to just like lift and whatnot. But yeah, the late great Kobe Bryant, rest in peace.
Indeed. Well, that brings us to the end of Q&A and the end of the event. Puya, this was amazing. I'm glad we got into such depth on the questions. Thank you for answering all those. Before we let you go, though, one more pop-up poll for everyone in the audience. Just give us a little feedback on this event and future events. You want to attend virtual events like this in the future. Now, in the meantime, Puya, want to extend our sincerest thanks for lending your expertise to the alumni community. And I'm happy to say that this event was recorded so that you can always come back and reference some of Puya's answers and insights into the patent world. So everyone join me, please, in giving Puya another great big virtual congratulations and thank you, Puya. We appreciate it.
You're welcome. Happy to be here.
All right. Thanks again. Now, everyone, as I said, the recording will be available. We have a couple upcoming really exciting virtual events, and we've been doing a wide variety of topics. So another one you may be interested in for a change of pace on July 1st, we have a graffiti masterclass with a professional street artist. Tickets for that one are limited, so sign up if you're interested. Our next Lunch with Eaters event, the 21st, is going to be held in August. So we're not going to do one in July. We're going into strategic planning mode. So keep an eye out for future promotion. Check our website for upcoming events. A lot of our chapters have upcoming events. We have a great one on June 23rd on navigating the hiring process for seasoned career professionals. That's part of our UC-wide Alumni Career Network. Reach out to us at alumni@uci.edu if you have any further questions. And thank you, more than anything, thank you for attending this event. Hope you have a great rest of your Friday and a great weekend. Take care, everybody. Zot, zot, zot.